I didn't look at my brother when I walked into the courtroom. I kept my eyes forward, my hands loose at my sides, and I sat down at the table on the left like I had every right to be there. Which I did. Even if no one in that room believed it yet. My brother sat across the aisle with his wife pressed against his shoulder like a shield. Their attorney, a man in his late 50s with silver cufflinks and a smile that never quite reached his eyes, was already arranging documents in a neat stack. Confident, unhurried, the kind of man who wins before he opens his mouth. I had no attorney. I had a folder, a yellow legal pad, and 3 years of knowing exactly what my brother had done. The judge hadn't entered yet. The bailiff stood near the door. The clerk typed something at her station without looking up. Everything felt ordinary in the way that moments do, right before they stop being ordinary. My sister-in-law caught my eye across the aisle. She smiled, small, satisfied. The kind of smile you give someone when you're certain they're already finished. I turned back to my yellow legal pad and wrote nothing. My father was diagnosed with early-stage dementia in the spring of the year he turned 74. He was still sharp enough to remember birthdays, still drove himself to the grocery store on Tuesdays, still called me every Sunday at 7 in the evening without fail. But something had shifted. He'd repeat a question twice in the same conversation and not notice. He'd leave the stove on. He'd call me by my mother's name. She had been gone for 11 years by then, and for a moment his voice would go soft in a way that broke something in me every single time. My brother lived 40 minutes from my father. I lived 4 hours away. That detail mattered more than anything else in what came next. When I visited that first summer after the diagnosis, I noticed changes, small ones. My father's mail was being forwarded to my brother's address. The car my father had driven for 6 years was gone from the driveway. When I asked about it, my father shrugged and said my brother had taken it to get serviced. It was never returned. When I asked my brother, he said our father had decided he shouldn't be driving anymore. Maybe that was true. Maybe it wasn't. I didn't push. I told myself I was being paranoid. I told myself my brother was handling things I couldn't handle from 4 hours away. I told myself a lot of things that year. The will was the one my father had written 9 years earlier, right after my mother died. I had been with him when he wrote it. I sat in the office of his attorney, a retired man named Gerald Hayes, who worked out of a converted Victorian on Elm Street, and I watched my father sign his name in that careful, deliberate way he had, pressing each letter into the page like it mattered. The will divided everything equally, half to me, half to my brother. The house, the savings, the small parcel of land outside town that my grandfather had passed down and which my father had never sold because, he said, some things weren't for selling. That will existed until about 18 months after the diagnosis. The new will, the one my brother produced after my father died, left everything to him, every account, the house, the land. A signature I recognized as my father's in the same deliberate handwriting, dated 14 months after his diagnosis, leaving me a single paragraph that said he loved me, but that he had decided, upon reflection, to make other arrangements. My father never said a word to me about other arrangements. Not once in 4 hours of Sunday phone calls. Not once in my visits. Not once. I hired a forensic document examiner with the last $2,000 in my savings account. She was a former FBI analyst named Dr. Patricia Osei, who worked out of an office in Columbus and who, when she called me back 6 weeks after I sent her the documents, spoke in the careful, measured tone of someone who has learned to deliver difficult information without emotion. She said, "The signature on the new will was consistent with my father's authentic signature in its basic form, but the pressure patterns were wrong. The ink distribution was wrong. The microtremors that appear in the signatures of elderly individuals with early cognitive decline were absent. The signature on the new will was clean in the way that a signature is clean only when someone takes their time, when someone practices, when someone is not the person whose name they are signing." I asked her if she would testify. She said, "Yes." The problem was the filing deadline. I had 30 days from the date the will was submitted to probate to contest it, and I had spent most of those 30 days trying to find an attorney who would take my case on contingency. 4 said no. 2 didn't return my calls. 1 told me I had a strong case and then quoted me a retainer of $15,000 I didn't have. On day 29, I filed the contest myself. The clerk at the courthouse looked at my paperwork for a long time. She was a woman in her 60s with reading glasses on a beaded chain, and she looked at me over the top of them with an expression that was not unkind. She said, "You know you can request a continuance to secure legal representation." I said, "I've been trying. I'll be okay." She stamped my documents and slid them back across the counter. I was not okay, but I was there. That had to count for something. The morning of the hearing, I called my daughter before I left the motel. She was 16, staying with a friend while I was away, and she had inherited my father's habit of calling things exactly what they were. She said, "Are you scared?" I said, "Yes." She said, "Do it anyway." I thought about that as I drove to the courthouse. I thought about it when I walked past my brother in the hallway without speaking. I thought about it when I sat down at that table on the left with my folder and my yellow legal pad and no one beside me. My brother's attorney, his name was James Cordell. I had looked him up. 17 years of probate litigation, a record that leaned heavily in favor of whoever had the larger estate, was speaking quietly to my brother at their table. My brother laughed at something. That soft, easy laugh he'd always had, the one that used to mean something to me. His wife glanced at me again and then looked away. I uncapped my pen. The judge's name was the Honorable Carol Whitmore. She was somewhere in her early 60s, with close-cropped gray hair and the kind of stillness in her face that comes from decades of listening to people lie. She entered the courtroom without ceremony, settled her reading glasses on her nose, and opened the file in front of her. She said, "This is a will contest filed by the decedent's daughter regarding the last will and testament of Raymond Earl Mercer, dated March 3rd of last year. Counsel for the proponent is present. The contestant is representing herself. Is that correct?" Cordell said, "That's correct, Your Honor." I said, "Yes, Your Honor." She looked at me over her glasses for a moment. Not unkindly. Not reassuringly. Just looked. "The way you look at something you're still assessing," she said. "We'll proceed." Cordell opened by laying out the case for my brother in smooth, unhurried language. My father had been examined by 2 physicians in the months prior to signing the revised will. Both had found him competent to make legal decisions. The will had been witnessed by 2 individuals who had known my father for years. His long-standing attorney had reviewed the document. That last part snagged something in me. Gerald Hayes, my father's attorney, the one who had helped write the first will. I had called his office 3 times. His assistant told me he was traveling and would return my calls when he was available. He never did. Cordell said, "The contestant's claim rests on the allegation of forgery, a serious charge made without legal training, without a shred of corroborating testimony from anyone who knew the decedent, and without any credible expert who has actually examined the original documents." I wrote on my legal pad, "Original documents." He continued for another 8 minutes. He was good. He built the picture of my brother as the devoted son, the one who had managed my father's care, arranged his appointments, modified the house when my father's mobility declined. He built the picture of me as the distant daughter who had appeared only at the end, clutching a grievance born from disappointment rather than evidence. He did not raise his voice once. When he finished, the judge asked if I wished to respond to the opening statement. I stood up. I said, "Your Honor, I'm not here because I'm disappointed. I'm here because my father did not write that will. I have a forensic document examiner who analyzed the signature and identified specific, measurable anomalies that indicate it was not authored by my father. I intend to call her as a witness, and I intend to ask the court to compel production of the original will document for independent examination." Cordell said, "Objection. Your Honor, the contestant has not properly noticed any witnesses." I said, "I submitted a witness list with my contest filing on day 29. The judge looked at the clerk. The clerk checked something. She nodded once. Cordell's jaw moved slightly. "Not much. Just enough." The judge said, "The witness is properly noticed. We'll proceed." The first hour was difficult. Cordell called the 2 witnesses to the will, a neighbor of my father's named Dawn Ashby, and a woman named Margaret Cleary who had attended my father's church. Both were confident. Both described my father as mentally present, engaged, fully aware of what he was signing. Both described my brother as attentive and caring. Both described me, without quite using my name, as someone who had not been around much. That was true. I had not been around much. I had a job. I had a daughter. I had a 4-hour drive and a father who I had believed, and perhaps still believed, was being managed well by my brother. That was the version of the story in which I was simply absent. In the other version, I was kept absent. I had not yet proven which version was real. When I cross-examined Don Ashby, I asked him one question. I said, "Mr. Ashby, were you present in the room when my father signed the document?" He said, "Well, I was called in to witness the signature itself." I said, "So you saw him sign it?" He said, "Yes." I said, "Did you read the document before you signed as a witness?" A pause. He said, "I know. I was just there to witness his signature." I said, "Thank you. Nothing further." I asked Margaret Cleary the same two questions. Her answers were the same. Neither of them had read a word of the document they had witnessed. Cordell called my brother to the stand. My brother is 2 years older than me. He has our father's build broad shoulders, a way of taking up space without seeming to try. He sat in the witness chair the way he sits everywhere, settled, unhurried, like the room had been arranged around him. Cordell walked him through the story with easy, practiced questions. My father had grown increasingly concerned about his care in the final years. He had expressed wishes frequently, Cordell emphasized, to ensure that the person managing his affairs would be someone locally present. He had come to his own decision. The revised will reflected that decision. My brother had not suggested it, had not initiated it, had simply, humbly, honored his father's expressed wishes. My brother said, "My father loved my sister. I want to be clear about that. This was never about love. This was about practical reality." He looked at me when he said it. Something in that look was almost sorry. I held his gaze. I wrote nothing on my legal pad. When it was my turn, I stood and I took a breath, and I asked the question I had been building toward for 45 minutes. I said, "You mentioned that my father came to this decision on his own. Were you present when he met with attorney Gerald Hayes to draft the revised will?" My brother said, "I drove him to the appointment." "Yes." I said, "Were you in the room?" A small hesitation. He said, "I may have stepped in briefly. To help with my father sometimes had trouble following long documents." I said, "So you were in the room when your father signed a document that transferred the entirety of his estate to you?" He said, "I was there to help him understand." I said, "Yes or no?" He said, "Yes." I wrote that down. I said, "Do you know where attorney Gerald Hayes is currently?" Cordell said, "Objection. Relevance." The judge said, "I'll allow it. Answer the question." My brother said, "Gerald retired. I believe he moved." I said, "Do you have contact information for him?" My brother said, "I don't. No." I wrote that down too. I was halfway through my own testimony explaining Dr. Osei's methodology, laying the foundation for her examination when the door at the back of the courtroom opened. I didn't look right away. Doors open during hearings, clerks enter, observers come and go. I kept my eyes on the judge and continued describing the ink distribution analysis. But the judge looked up, just briefly, and then Cordell turned, and then the bailiff shifted his weight in a way that meant something. I stopped talking. The man who had entered was somewhere in his mid-40s, with dark hair going gray at the temples and a charcoal suit that had the particular quiet quality of something expensive. He carried a briefcase in one hand and a sealed manila envelope in the other. He walked to the front of the courtroom without hesitation and stopped just inside the bar. He said, "Your Honor, I apologize for the interruption. My name is David Reeves. I'm an attorney licensed in this state. I represent Gerald Hayes." The courtroom went very still. The judge said, "Mr. Reeves, you're not a party to this proceeding." He said, "No, Your Honor, but my client is a material witness who was unable to appear in person due to a health situation. He has provided a sworn affidavit and supporting documentation that he believes are directly relevant to this matter. He contacted my office 4 days ago. I apologize that we were unable to provide earlier notice." He held up the manila envelope. I looked at my brother. My brother was looking at the envelope. His face had changed. Something in it had gone tight in the way that faces go tight when a person is working very hard to stay composed. His wife put her hand on his arm. He didn't move. The judge called a brief recess to review the materials. I sat at my table and stared at my legal pad and did not let myself think too far ahead. I had learned over the past 3 years that hoping too specifically was its own kind of damage. Dr. Osei had flown in from Columbus that morning. She was seated in the gallery, a compact woman in her 50s, with a gray blazer and the posture of someone who has testified in federal court and found it unremarkable. She met my eye briefly and gave me a small nod that meant nothing except, "I'm here." My brother and Cordell were in quiet, close conversation at their table. I could not hear the words. I could see Cordell's expression, which had shifted from confident to careful. That was something. When the judge returned, she set her glasses on her nose and looked at the papers in front of her for a long moment before she spoke. She said, "Mr. Reeves, your client's affidavit states that he was contacted by the proponent of this will approximately 16 months ago and asked to prepare a revised document. He states further that during that meeting, the decedent was not present, that he was asked to prepare the document based on instructions provided by the proponent, and that he was told the decedent would sign at a later date." The courtroom was silent. She said, He states that he did not personally witness the signature on the revised will, that he was subsequently provided with a countersigned copy, and that he had concerns about the validity of the execution, but that he had been, and I'm quoting here, assured the matter was properly handled. He states that he retired shortly after and relocated, and that he has been contacted multiple times by this court in connection with this proceeding, but that those communications were directed to his former office address, which was closed. She took her glasses off. She said, he also enclosed the original drafting notes from the meeting, which do not include the decedent's name anywhere in the notes as a participant. Cordell said, Your Honor, the affidavit of a single witness. The judge said, Mr. Cordell, I'm going to ask you to let me finish. He stopped. She said, The affidavit also includes a letter from Mr. Hayes to the proponent, dated approximately 12 months ago, requesting confirmation that the execution of the revised will was properly witnessed. He never received a response. He states that he did not feel comfortable coming forward sooner due to concerns about his own liability, and that it was only after reading a notice in connection with this proceeding that he instructed Mr. Reeves to bring these materials to the court's attention. She looked at my brother. She said, The court is taking a 90-minute recess. I'm directing the proponent to remain available. Mr. Cordell, I'd like to speak with you in chambers. I sat in the hallway on a wooden bench outside the courtroom and drank a cup of bad coffee from a vending machine down the hall. Dr. Osei sat beside me. We didn't talk much. She asked if I had eaten anything. I said no. She handed me half a granola bar from her briefcase without comment. David Reeves came out through the courtroom door about 15 minutes into the recess. He looked at me and then sat down on the bench across the hall. He said, I want to be clear that I'm not representing you. My duty is to my client. I said, I understand. He said, Gerald Hayes is 78 years old and in poor health and has been carrying this for over a year. He wanted you to know that. He said he knew your father. I said, he drew up the first will 9 years ago. He said your father brought a photograph of your mother to that appointment. He kept it on the desk the whole time. He said your father talked about her the entire time they were waiting for the notary. I didn't say anything for a moment. I said, that sounds like him. Reeves nodded and looked down the hall and then back at me. He said, you should know Cordell is going to push for a continuance. I said, of course he is. He said, I don't think he'll get it. He stood up and straightened his jacket and walked back toward the courtroom doors. I finished the granola bar. I thought about my father sitting in Gerald Hayes' office with a photograph of my mother on the desk. I thought about his voice going soft on Sunday phone calls when he forgot himself and used her name. I thought about the land outside town that my grandfather had passed down because he had said some things weren't for selling. I thought about my daughter's voice that morning. Do it anyway. When court reconvened, Cordell moved for a continuance. The judge denied it. She said, the evidence before this court at this stage raises substantial questions about the validity of the execution of the revised will. A continuance would not resolve those questions. Additional expert testimony would. The court is prepared to hear from the contestant's document examiner. Dr. Osei took the stand. She was precise and unhurried. She explained her methodology in language that was technically rigorous but never condescending. She explained what a baseline signature sample looks like for a subject with early-stage cognitive decline. She explained what pressure distribution tells you. She explained the microtremors. She said, the signature on the contested will does not match the authenticated signature samples in 14 out of 17 measurable parameters. The probability that both signatures were produced by the same individual, accounting for natural variation and the documented progression of the decedent's condition, is approximately 3%. Cordell's cross-examination was aggressive. He challenged her methodology, her sample size, her credentials, the chain of custody of the documents she had examined. She answered every question in the same steady register. She did not become defensive. She did not become uncertain. She simply answered. At one point, Cordell said, isn't it true that forensic document examination is not a recognized hard science? She said, it is true that it is not classified as a hard science in the same category as, for example, DNA analysis. It is also true that I have testified in 41 federal cases, that my findings have been accepted as evidence in 39 of those cases, and that in the 2 where they were challenged, those challenges did not concern methodology but admissibility rules specific to those jurisdictions. I'm happy to provide that documentation if the court would find it useful. The judge said, the court would. Cordell sat down. After Dr. Osei stepped down, the judge asked if the proponent wished to call any additional witnesses. Cordell conferred with my brother for a long moment, long enough that the silence in the room became its own kind of statement. He said, "The proponent has no further witnesses at this time, Your Honor." The judge looked at the papers in front of her. She said, "This court finds that the proponent has not met the burden of demonstrating the validity of the instrument submitted for probate. The forensic evidence presented, combined with the sworn testimony of the drafting attorney and the absence of any direct, credible evidence that the decedent was present at or a willing participant in the revision of his testamentary documents, is sufficient for this court to set aside the revised will and reinstate the previous valid instrument dated 9 years prior." She looked at my brother. She said, "The court is also referring the matter to the county prosecutor's office for review of potential criminal liability in connection with the execution of a fraudulent legal instrument. That referral does not prejudge any criminal proceeding. It is simply this court's obligation when evidence of potential criminal conduct comes to its attention." She took off her glasses. She said, "We're adjourned." I walked out of the courthouse into the afternoon light and stood on the steps for a moment. The air was cold and clean the way October air is, in the Midwest, sharp at the edges, carrying the smell of leaves and something distant. Behind me, I heard my brother's voice saying my name. I turned. He was at the top of the steps. Without Cordell, without his wife, his hands were in his coat pockets, and he looked tired in a way I hadn't seen before. Tired in the bones, not just the face. He said, "I thought he stopped." He said, "I thought he wanted it." I told myself that he would have wanted it, because I was the one who was there. I said, "He didn't want it." He said, "I know that now. I think I knew it then." I didn't say anything. He said, "I'm sorry. I know that doesn't." I said, "It doesn't fix anything." He said, "No, it doesn't." We stood there for a moment. Below us, cars moved through the intersection. A woman walked a dog past the base of the steps. Everything ordinary again. I said, "I need some time." He nodded. I walked down the steps and got in my car and sat there for a while before I started the engine. I thought about calling my daughter. I thought about calling no one and just driving. I thought about the parcel of land outside town, the one my grandfather had passed down, the one my father had kept because some things weren't for selling. I thought about what it would mean to stand there, just stand there, in something that had survived all of this. I started the car. 7 months later, the county prosecutor filed charges. The case is still pending. I don't know how it will end. What I know is what the judge said, and what Dr. Osei proved, and what Gerald Hayes finally told the truth about from a house in another state when he was 78 years old and tired of carrying something that wasn't his to carry. What I know is that I walked into that courtroom alone, and I walked out with what my father had always intended for me. What I know is that the land is still there, outside town, unchanged. I went in November, a few weeks after the hearing. I parked on the gravel road and walked the fence line the way my father used to when I was small, and he held my hand and told me about his father and his father's father and the way things pass down when you take care of them. I stood there for a long time. My phone buzzed. My daughter. I let it ring twice before I answered, smiling already before I said a word. She said, "So?" I said, "So it's over." She was quiet for a second. Then she said, "I told you." I said, "Yeah, you did." The light was going. The field was gold and gray and still. I thought about my father's voice on Sunday evenings, the way he always said goodbye twice, once when the conversation ended and once just before he hung up, quietly, like an afterthought, like he wanted one more second. I said goodbye to the field. Then I went home.